Hello, hi, how are you? Welcome on in to a series of quick takes on Podcast by George. I was recently very honored to participate in a First Amendment and libel law panel at Iowa State University with some really smart people and some experts on the world of journalism in America today. And it couldn't be more important. You've heard me talk on the podcast many times about the fact that our country is continuing its steady slide. It's careening, really, toward the right. It has been ever since Ronald Reagan, my adult lifetime, basically, and they're coming for us, folks. You've seen some of the coverage coming out of Oklahoma on abortion rights, Texas and the schools, the climate is not being dealt with. People are refusing to recognize it, clamoring for more oil, more gas, drill, baby, drill. Well, they're coming for journalists too. That's another part of this, and that's what we're going to be talking about today. And the title of the panel was Attention All Content Creators. You should care about the First Amendment, and that's what this panel was about. But it's not just for content creators. If you're a consumer of content, and everyone is, this should be of extreme interest to you. And it reads that if you create content that is published online, in print, in audio, anywhere, a Supreme Court case called New York Times versus Sullivan affects you. Sullivan is the landmark case that in 1964 decided the First Amendment protects the free flow of information, including occasional mistakes, as long as our mistakes aren't malicious or reckless. But there has been talk recently of dismantling Sullivan. What would that mean for content creators, large and small? Hint, we should all be worried. And that intro is written by Julie Rosa. She's the assistant professor and First Amendment specialist at the Greenlee School of Journalism and Communication. And the panelists included Jeffrey Hunt. He's a shareholder at Parr Brown G and Loveless in Salt Lake City, Utah, an expert on First Amendment and libel. Jared Strong, who people should be familiar with. He's a senior reporter at the Capitol Dispatch, Iowa Capitol Dispatch, turning out a lot of great stuff. I was on the panel. And of course, Julie Rosa. And I want to give her a little bit of notice here. People have seen me appear at Iowa State University virtually in front of her classes. Julie's classes include First Amendment law, media law, and principles of journalism. She chairs the First Amendment Committee, which coordinates events throughout the year for the Greenlee School's First Amendment series. Now, the most prominent event in the series is ISU's annual First Amendment Day celebration, which this panel was a part of. It's a nationally recognized event since 2002. Rosa serves as a resource on legal issues related to freedom of speech and press. She also provides outreach and training on First Amendment topics to the campus and community. She earned her law degree from Drake University Law School, where she also earned a master's degree in mass communication. She earned her bachelor's degree in journalism from Iowa State University. And, of course, she's also a member of the Iowa Bar. So thank you, Julie Rosa, for including Podcast by George on the panel. And we're going to get to our first speaker here, and it's going to be Jeffrey Hunt. He's going to give an outstanding overview of the New York Times versus Sullivan ruling. And many people will be surprised to know that not only did it come out of the early 60s, but it came out of the Jim Crow era, is specifically linked to that, and it also didn't come out of a news story. It came out of an advertisement. Here is Jeffrey Hunt with the background.
Was not over a piece of reporting. It was over an advertisement, a full-page advertisement that ran in the New York Times in 1960. And so to understand the case, you really need to understand the cultural, political context at the time. So this is 3 years after Brown versus Board of Education, but before enactment of the Civil Rights Act. And so it was a time of massive resistance in the South to Brown versus Board, to integration of public accommodations. And the New York Times, of course, was covering this very closely. They had a fleet of reporters down in the South covering the civil rights protests. And the advertisement in question was placed by a group of supporters of Martin Luther King and the civil rights protesters in the South, and included a number of really notable figures: Harry Belafonte, a number of other famous actors and actresses, civil rights leaders, including Ralph Abernathy, Fred Shuttleworth, J.E. Lowry. More than 60 people signed this advertisement, and basically the ad criticized the conduct of the law enforcement authorities in Montgomery, Alabama, concerning the treatment of the civil rights protesters. And it was titled "Heed Their Rising Voices." And the Commissioner of Public Safety in Montgomery, Alabama, was L.B. Sullivan. He did not care for the ad. He did not care for the civil rights protesters. And he filed a libel lawsuit in circuit court and state court in Montgomery, Alabama, claiming that the ad had libeled him, even though he was not named in the ad. The ad just referred to police generally. These days, that would be enough to get a lawsuit like that dismissed, because to be defamatory, the statement has to be of and concerning a specific individual or a small enough group that you could identify that individual. This would not have satisfied that test. But he sued anyway, and he asked for and received a libel judgment against the New York Times of $500,000. Now, at the time, that seems like today that's kind of not much money, but back then that was a lot of money. It was a record libel judgment in the state of Alabama. Nothing had even come close to it. And of course, a series of such judgments would, essentially bankrupt even a publication as well-heeled as the New York Times. Not to mention the smaller papers in the South that were trying to do that type of journalism. And so the judgment was appealed to the Alabama Supreme Court, which hastily and perfunctorily sustained the judgment. And then from there, the New York Times appealed to the United States Supreme Court. And so when it got to the United States Supreme Court, it was 3 to 4 years later, 1963, 1964. And the strife in the South had continued. And so the justices, they read the newspapers. They knew what was going on in the South, thanks to the reporting of organizations like the New York Times. And that was the prism through which they looked at this defamation lawsuit. And for context, at this time in 1964, there were no constitutional limitations on defamation lawsuits. There was no First Amendment limitations on libel lawsuits. So the court was confronted for the first time with whether the First Amendment imposed some limitations on a public official suing the press for speech that was critical of their official conduct. Okay, so this wasn't speech that was critical about L.B. Sullivan's private life. This was about, even if you accept his theory that it was about him, it was about official police conduct. And the argument that was made by the New York Times attorney was that there ought to be some First Amendment limitations on such actions, because the First Amendment at its core protects speech about the government, and the government shouldn't be in a position to retaliate and enforce ruinous monetary judgments to silence critics, because that's essentially what L.B. Sullivan was trying to do. He wasn't concerned about his reputation. He wanted to send a message to the civil rights leaders and the press that was covering them that I can do this to you. I can silence you, and that would essentially chill speech, chill reporting about this very important issues going on in the South over race. And so that was the argument for the Times attorney. The argument for Sullivan's attorney was libel law has never been a constitutional matter. At the time of the framing of the Constitution, it was English common law that controlled libel actions. America adopted that under English common law, as in Alabama at the time. If the statement was defamatory, intending to injure someone's reputation, damages were presumed. Falsity was presumed. And the burden of proving the truth was on the defendant. Okay. The burden wasn't on the plaintiff to prove falsity. It was on the defendant. And so that means that almost every case is not going to get dismissed at an early stage, because you're going to have a trial over what was factual and what was true and what was not. And of course, that's expensive, and a lot of smaller papers could not afford that kind of litigation. So what would they do? They would steer away from that line. They would not report on those vital issues that need covered. But that was the law at the time. And so the import of the decision, which was a 9-0 decision, it was a unanimous Supreme Court decision, was that the First Amendment does impose limitations on the ability of a public official to sue the press or anyone who makes a statement that's critical of their public functions. And the test that they created is the actual malice test. And the idea was that the First Amendment needs to provide some breathing room for the press to do its job. And the core of that is covering the functions of government. And when the press is covering things, reporters are human, they make mistakes. There are going to be errors. And the idea here was that if you make an error and it wasn't intentional, it wasn't knowing falsehood, that would not be enough to sustain liability by a public official suing the press. So it created some protection for the press to make good faith errors and not be subject to ruinous, financial judgments by public officials suing them. And since then, it's become one of the great landmarks of press freedom, not just in the United States, but in the world. If you go on the United States Supreme Court website, there is a list of they call them landmark decisions. And you have Brown versus Board, you have Mapp versus Ohio, one vote, one person, one vote. You have a number of these critical decisions, and New York Times versus Sullivan is there, right up with the rest of them. It's really a beacon of press freedom, and it's what has allowed for the citizens in this country to get the kind of news that they should be getting regarding public officials and their conduct.